This is Doug Brunke of Global Chamber. We're very pleased to be here in the offices of Polsinelli in Phoenix, Arizona for a very global conversation about GDPR. I've personally looked at the social media tweets recently and Facebook, and I see a lot of people a little bit scared about what's coming, and I see actually more people just somewhat, hey, I'm sick and tired of hearing about this. I also saw a survey that said only 2% of companies doing business in Europe are prepared for GDPR, and that's a week away. So I think there'll be a lot of people really busy, and so the purpose of today was to bring in some experts and talk about, how to get prepared. Even if you haven't done anything, hopefully today's presentation will be able to get you there and also give you some resources to work with. One of those resources is here with me in Phoenix. It's Mike Patterson. Let me introduce him of Polsinelli. Mike, thank you.
Thank you, Doug. This is a really important, awesome conversation, and for us in the U.S., really important to understand how laws around the world affect us, and the GDPR, I think, is going to be just a really interesting example of how global we are in the world. A lot of people are going to wake up and realize, I've had clients that have said, oh, this doesn't apply to me, and we developed a tool here in our firm, a self-assessment tool that Garrett is going to share in just a moment. And a lot of people are, in the U.S. are saying, oh, this doesn't apply to me, and we know different when they're collecting data in the EU. And I think I'm hopeful that this exercise as a tangential thing will help a lot of people realize that they do have global operations that are important to them and that they are interconnected beyond what they realized in their companies. And this will be opportunities for folks like Chris Williams from the UK, who I have a client relationship with, and who has really come into the U.S. and has done amazing things with some important companies here with his app building and his technology abilities, and helping those clients who they have a global footprint. And very happy to have a relationship with you, Chris, and Anne, glad you're here with us today. And I'm going to turn it over to Garrett Steenblick from our firm.
Bonjour Anne, Laure. Enchanté de faire votre connaissance. Chris, nice to meet you as well. I'm the honorary French consul for Arizona, and have worked with French clients for a number of years. We are really grateful to Alain, who has taken the initiative of trying to get us together to talk about these issues today. They're important, they're timely. We're very thankful to Doug Brunke for his efforts to constantly keep global business in the forefront here in Phoenix. We welcome you to our offices, and we are excited about this new relationship. And Anne, I hope in particular that we'll have a chance to get better acquainted. I will say that everyone is now talking about GDPR, and as Doug mentioned, some people are tired of talking about it, but very few people know very much about it. Last night on the BBC's World Business Report, there was an interesting story about GDPR, a woman who went through the fact that now there's sprung up a cottage industry of people who are offering to basically take over the GDPR compliance obligations for a number of companies offering their services. And most service providers, most lawyers and professionals and accountants have got some kind of a tool available for this. We have produced a couple in our office, but I'm really excited to get the international perspective from Anne-Laure and Chris today on that. The BBC reported last night that some clients are making the mistake of thinking they can go online and figure all of this out. The reporter told the story of one company who spent hours going through a detailed checklist online, putting in all of their confidential information that they could into the form, and then clicking the next button, where it says, if you want to proceed further, whatever, And in this case, they click the next button and it says, now for $10,000, we will give you your assessment. At which point they expunged all of their data from the form and went back to square one. Well, that's the purpose of this today, is to save us that kind of a headache and to allow us to get a little bit of our arms around this particular issue. And we're delighted to have you here. Polsinelli is delighted with this relationship, and we thank you for joining us today.
Thank you, Mike. Thank you, Garrett. Thank you, Polsinelli, for hosting us here in the location. And thanks to all of you around the world. And Laure, your office is in Paris. Although you are outside of Paris today, you're bringing us a very more detailed view of, from a European standpoint, what we need to be doing. And so we really appreciate you taking us through a very heavy topic in a short amount of time. And then when you're done, we're going to switch to Chris briefly, and then we'll have time for Q&A. And Laure, please.
Good morning to the participants. So my name is Laure Galline Castel. I'm a notaire at law in Paris. We will be joined by Philippe Pays, who is a DPO, Data Protection Officer in Paris as well, and we will share with you our experience on that on the GDPR project. This event is organized by the Valdoise Economical Agency, and thank you for the partnership between Phoenix and the Valdoise. The purpose of this presentation is only to give you a general overview of the GDPR, to give you the key concept of the regulation. So what is the GDPR? The GDPR is a European privacy law which becomes enforceable on May 25th. It intends to create uniformity between the data protection law through European Union. And the purpose, in fact, is to give back to the individuals control of their personal data. As you see, European Union is a very broad territory. And if we go on the next slide, the GDPR scope is very broad as well, because it applies to all organizations that have an establishment in European Union or that offer goods or services to individuals in the European Union when processing personal data of EU residents, that mean your companies. So it applies to all data of individuals who are residencing in the European Union, whether or not the data are processed or stored within European Union. The criteria, in fact, is residency, not citizenship. Which company does the GDPR affect? All the companies that process European resident data, even if they have no business presence in Europe. So Facebook, Google, Amazon, they already have committed to comply with GDPR. But what is the personal data? This is very, very broad as well. The definition is any information relating to identified or identifiable natural person. And this identifier can be, for example, the basic identity information, such as name, address, pictures, video, diploma, ID numbers, but it can also be web data, such as location, IP address, cookies, RFID tags. In addition, there is a special treatment for sensitive data, health and genetic data, biometric, racial data, political opinion, and sexual orientation are sensitive data. Sensitive data, the principle is that it's prohibited to process sensitive data because it can discriminate people. and the sensitive data in Europe benefit from a special protection. But there is 3 exceptions to process personal, sensitive personal data. These exceptions are explicit consent given by the person, the individual, or processing is vital for the data subject. If I give you an example, if I go to a lab and there is some blood work done, it is vital for me that a doctor read the results. So this is for my vital interest. The third exception is the processing for vital, when the processing is vital to public interest. Now, what is processing of the data? What is the processing? So it's any operation which is performed on personal data, like collection, recording, storage, adaptation, disclosure, and even destruction. Now, what is the big deal with GDPR? In fact, GDPR gives individual more rights. And these rights, the first one of these rights are the explicit consent for processing. It's a key concept. The consent must be explicit and in connection with the data collected and for the purpose the data is used. It means that your company must obtain the express consent from every individual to process their data. For example, by signing an express authorization or checking a box to accept on a website. In case of control, you have to keep some piece of evidence that you have collected consent. So back up all consent. Then, information rights. This is the second very important right of individuals. The individual have the right to be informed about the processing of their personal data. The data user or data controller must provide an explanation of the logic involved in the processing of the data and make available to all individuals information about what data is being gathered, for what purpose, where it will be processed, stored, and with what organization the data might be shared. So it is important to know exactly where is the data and for what purpose it is used. Then, individuals have a right to access and correction, but this is not new. It exists since a long time in Europe. So they have a right to access the data and request correction. This right shall be free and executed within 30 days. And it is very important for the company to take into consideration every request made by individual, because if you don't give access, or if you don't correct, if you just ignore the demand, the request, then you can be denounced to the authority and be fined. Transfer right. This is the right to obtain the transfer of your personal data from one organization to another organization without obstruction and undue delay. And after the data are transferred, the previous organization shall delete the data. Erasure right. The individuals have the right to request erasure. It means that all the data must be deleted. This is the right to forgotten. So it was to summarize all the rights of the individual, but the GDPR is more give more details about the principle that govern all processing of personal data. The idea is to define the condition on which data processing is permitted. And the key concept is that the data can only be collected for specified, explicit, and legitimate purposes, which means that it won't be acceptable to collect data first and figure out after how it could be used. Then the organization that collect data, personal data, shall only collect the minimum amount necessary to perform the task. And they have a responsibility to restrict this collection and to the minimum. And to give you an example, is it necessary to collect exactly the date of birth? Or maybe to achieve your purpose, you can only collect the age, for example. This is an example. Another example, is it necessary to collect the address, the physical address of the person if you don't deliver anything? So the organization has to question itself on the type of data they shall collect. In addition, the organization is not shall not keep the data after it is no longer needed, so it shall destroy it. There is a key person in this new regulation. This is the Data Protection Officer, DPO. He's not responsible for the implementation of the GDPR. It's just an help. The top management is responsible for the implementation. But he's a key man. He's a key man because he will maintain the records of processing operation. He will inform, advise organization employees and advise about the risk assessment or impact assessment. He's also the person that will cooperate with the authority. If you go on the next slide, the Data Protection Officer is not mandatory except in 3 cases: public authorities, large data processing organization, or for organization which collect and process sensitive data. But otherwise is not mandatory. This DPO can be an employee or it can be outsourced, and normally is an expert who have knowledge strong knowledge in IT and strong knowledge of data protection law and a strong knowledge in IT as well. So what will change in the organization? The companies or any organization shall be able to demonstrate the security and the compliance with the GDPR on continual basis. That means that they have to hold formal documentation like registers, record of consent, information policies, and also mandatory agreements with subcontractor. They also have to perform risk assessment, and they have to manage the request or the claims to ensure the respect of the rights of the individuals. And if they are not compliant, their activity may be considered as unlawful under GDPR. So the organizations, the companies, shall mitigate the risk of data breach by implementing some measures, some security measures like pseudonymization, encryption, access control, and they shall be able to ensure ongoing confidentiality, integrity, availability of processing systems, and they have to test regularly the effectiveness of their systems. In addition, that's new. The organization must integrate privacy protection of personal data at the beginning of new projects. It means at the design stage of any project, they have to make privacy by design or privacy by default. The data must be data protection must be embedded into business processes and operations rather than afterwards. In addition, the organization must train and make aware its employees and any stakeholders of the protection of personal data. In case of data breach, an organization have 37 hours to inform the authority, and a data breach can be, for example, if you lose your laptop in the train with personal data inside, it's a data breach. And if the breach poses a high risk, high privacy risk for individuals, if, for example, if there is some sensitive information in the laptop, the individual shall also be notified. So I would like to give you an example. For Facebook, if GDPR was enforced earlier, the company Facebook should have informed European authority of the data breach. Third-party responsibility, what is it? If you outsource part of your processing to third parties, for example, IT provider, accountant, then you have to make sure that they have sufficient guarantees, sufficient security. And they have also to notify your organization if there is any breach of security in their organization. The third party is a very important new concept in the GDPR because he is as responsible as the data controller. So there is now some mandatory provision to add in agreements between a subcontractor and the data controller. For example, the third party must only process the data with written instruction of the controller. And if he deviates from this instruction, he may be personally liable. So, so you have to make sure that your subcontractor is compliant with GDPR and have an adequate security level. Now, cross-border transfer. Privacy Shield enables the US-based organization to receive personal data of EU residents. This is a program that is organized by the International Trade Administration, ITA, and you just have to self-certify to the ITA and publicly commit to meet the requirement of the Privacy Shield. And the Privacy Shield is a mirror of requirements of the GDPR. And once you have publicly committed to comply with the Privacy Shield, then GDPR becomes enforceable under US law. Non-compliance, very big penalties, in fact. Well, in case of non-compliance, the authority may be able to issue fines up to 20 million euro or 4% of the annual worldwide turnover, whichever is higher. For example, if you have a small subsidiary in France, the penalty will apply to the group level in the US. But I would like to reassure you because there is many steps before the application of such fines. The authority can give formal notice, formal notification to comply before applying the penalty. So the impact is more on the brand of the company before being a financial issue. This concludes my presentation. Thank you for attending. You may have some questions. I've prepared two questions in case of. So what will GDPR preparation cost to my company? Well, the amounts are very, very high, but it's a survey between 1 million and 10 million US dollar. Seems to be very, very big. But I think it's for big companies. And I had another question. The second question is, Alan asked me if we could make a disclaimer to avoid compliance with GDPR. I would say no, impossible, because European organizations shall be obliged to be compliant with GDPR to process personal data, and they may only make business with companies that respect GDPR. So if your company doesn't respect GDPR regulation, you may lose the client. Well, it's the end of my presentation.
Thank you, Laure. And I understand Philip will also be part of the Q&A, and so stick around. We're going to shift over to Edinburgh, Scotland, and Chris, actually, his company, B60, he's the chief executive, based, I believe, in London. And Chris, I think one of the questions that we've got is, and I've noticed this on the Polsinelli questionnaire, that it has the United Kingdom on here, and I've been assuming that GDPR only covered EU. Does it actually cover business in the UK as well? And thank you, by the way, for speaking, and that's my segue over to you in Edinburgh.
Well, thanks very much for having us. I guess to answer that question before I can continue with my very short presentation, the answer to that is yes, is that the UK, irrelevant of Brexit, have adopted those laws and the regulatory standards that are there. So yes, it does apply to the United Kingdom as it currently stands. So thank you very much for inviting me to participate in this presentation. I'll just flip to my slides now, which hopefully should display onto the screen in just a short moment. So hopefully they're visible now to the audience watch. So let me just give you a brief to who am I. My name is Chris Williams. I'm the chief executive at B60. We're a global mobile application development company that works with global brands and enterprises in the UK, Europe, and in the US and further afield. We essentially help organizations through their digital transformation journeys as a management consultant as well as a technology business. And so GDPR is something that we very much have come across in helping and working with our organizations. That we work with. But specifically, I was requested to join today's seminar to talk about really what it means to a CEO such as myself running a technology business, and how we're working with our clients to support them through the transitional phase that is obviously here and in place. So I was going to focus specifically on two areas, and the first area I was going to talk about was sales and marketing. Because as a CEO, you're responsible for a whole raft of things in the business, but ultimately you're the head of the captain of the ship, as it were. But sales and marketing is a critical part of any business operation. And specifically, I pulled out this particularly part of the regulation that effectively, from a sales and marketing standpoint, many businesses around Europe and around the world rely on their marketing communication channels in order not just to continue with their sales operations, but also to ensure that they're providing a good quality of service to their clients. And many a question that gets posed to us, especially around the mobile technology sphere, because so much emphasis has been put on websites from a digital standpoint and far less on the mobile area. Well, you know, how does it affect us, and can we still market to the users of our mobile applications and services? And the answer to that is well, yes, you can, but as Anne-Laure said earlier on, it's all about explicit consent. And as it says there, the processing of personal data for direct marketing purposes may be regarded as carried out for a legitimate interest, but it's all about explicit consent. And so it's very important to ensure that as you not just a going ahead and moving into developing new applications, but historical technologies that have been developed are actually assessed as part of the process of gearing up for GDPR. And this doesn't have to be particularly taxing. It is a series of work that needs to be carried out, but anything effectively that has the ability to collect personal data, naturally, of course, needs to be considered and looked at. But from a sales and marketing standpoint, GDPR isn't something that's there to restrict business, it's there to effectively aid it, but to be done in the right way. And I'm very much an advocate of, well, if you're an organisation that cares about its customers, you ultimately care about the protection of their data. And it's about empowering them as the users of those solutions that you're providing them to control their data. The next question that we're often very much posed is, well, can we still email or connect with our customers via their mobile technical devices? And the answer to that is, well, yes, again, as long as there is explicit consent that has been there, or as it says here, there's such a legitimate interest that could exist, where there has been a relevant and appropriate relationship between the data subject and the controller of that data, such as where the data subject or the client, the service of the controller. So, of course, communications can still pass backwards and forwards, or more importantly, as the data controller, you can still pass that information, but effectively it's got to be something that the customer has given explicit consent for. So from a sales and marketing standpoint, as a CEO, it's something that naturally we've spent quite a lot of time working to ensure that we do have that explicit consent, and our clients do as well, through the appropriate management and assessment of data and assessment of the technology solutions that are in place, that are being used. The second point for me as a CEO is very much around data security. And specifically, I pulled out just some extracts here that for me are quite important for all organisations to be very conscious of and cognizant of. And indeed, many of these were touched on in the previous presentation. So rather than going through each of these, because they have been covered, I wanted to highlight the third one on that list there from a development standpoint for new technologies moving forward, irrelevant of where your organisation exists. If it has customers inside of the EU, there is an absolute requirement and need to ensure that your technology design protocols and principles are updated to ensure that the application developers are building in the security in an approach that's a significant shift from the current practices, because current practices don't necessarily operate in that way. It's all about, well, how much data can we get and what can we track in order to provide the appropriate user experience, but it's about giving the user the right to choose what experience they need to have. So how can you go about doing that effectively? Well, from a mobile application specific standpoint, if you're collecting data, as we've already said, seek the explicit approval, ensure the privacy policy is available inside the application. You know, almost 7 out of 10 applications that we reviewed and researched ourselves within B60 found that many current applications didn't have the appropriate levels of privacy policies in there. It's easy to adopt and add in. These don't have to be particularly taxing updates, but it's something that must be done. And a key step here is to give the user control. And if you want a mobile application to succeed, whether it's especially in the consumer marketplace, it should really be all about giving them an excellent user experience, and the same principles apply. But it's all about giving your user control. There's been a lot of scaremongering around GDPR, and whilst it is a huge legislation and hugely important, it's actually something that should drive companies to deliver a much better user experience for their clients when deploying especially mobile technologies into their client bases. So a very short and brief presentation there as I was asked to deliver, but I hope that that's proved insightful for the audience there, and I'd be absolutely delighted to answer any questions that may come with that. And if anybody would like to connect with me directly, you're more than welcome to do so via the details on the screen.
Thank you, Chris. And this is Doug back in Phoenix, Arizona. So if you're viewing from around the world, then type in your question into the question box, and we'll be monitoring that and answering those. I know several of you have already, so thank you very much. And so with your questions there, anybody that's here has a question, please come up and we'll have you ask the question in front so that we don't have any loss of what what you're trying to say. And we also have Alan Carey, who will do some translation between French and English if necessary, especially Philippe might be helping and Laure through that. So Chris, I know you're going to be okay. So one of the questions is about a word that you used, and Laure, pseudo-migration, and that appeared to be maybe a French word or something that was Greek, but it actually is an English word. Could you? Is there a simpler word than that? I actually Wikipedia it, and it is a real word, so you spelled it absolutely correctly. Could you talk a little bit about what that really means, and how does a layman kind of handle that whole topic?
Excuse me, can you repeat the word I said? Because I...
Pseudo-migration.
Did I say that? Are you sure I did? Maybe I'm to be honest, I don't even see what you're talking about.
Okay, well,
did I say that? Pseudo-migration?
I'll frame it up in another way.
Maybe if you write it, I will but
I'll frame it in another way. Really what it was talking about.
Okay, I say pseudonymization. Okay, it means that you...
Easy for you to...
Sorry. It means that you have to anonymize the data to... does it make sense? Alan, are you here? Because we need translation.
It makes it anonymous, Alan.
Yes, make it anonymous. This is what I wanted. Pseudonymization. Okay. Make it anonymous. So, so the data cannot cannot identify a physical person. This is one of the security measures.
Okay, gotcha. So kind of going along kind of that same line, the questions kind of around CRM and newsletters, there's some confusion in terms of, I mean, if you're sending out, data to prospects, it's hard to make them anonymous, right? You've got to have some specific information. And it sounded like, Chris, you were talking about the ability to keep some data if they end up being potential clients. How does a company handle a CRM database, given that likely many of them will not have opted in, if you will?
I think it's important to separate the difference between, I guess, again, the sales and marketing element of this from a prospecting database standpoint, and the other side of this, which is the storage of that data that an organization has on a particular individual. So I guess trying to, I'm not the lawyer here, but I'll try and put it in the layman's that as I understand it, and I'm sure I'll be heavily corrected by the lawyers that are on this session. But talking about anonymizing data and ensuring that data is anonymized in some way. If we look at that from a data storage standpoint, if that data in some way was stolen, the example given before was a laptop left on a train or something like that, and it held customer information, that needs to be encrypted in some way. That data needs to be kept in some way so that it's anonymous to people. There's many different ways that it can be looked at in that regard. But I think if we look at it from the sales and marketing standpoint, the fact of the matter is, if you have prospecting data on a CRM, a customer relationship management system, where you are having intention to prospect out, it's all about where have you acquired that data from. Have you been given explicit consent to market to those individuals? Have you purchased that data before this? If you have, then there's a fine line there. Or ultimately, those individuals have not requested for you to connect or contact them. So it's important that communications are sent out now to advise that CRM, is it okay for us to continue to engage and communicate with you, and give them, the receiver of that information, the opportunity to update what it is that they receive and to update the information that you are holding on them. That's my interpretation and understanding of that across the board.
Okay. And Laure, is that, and Philippe, is that your interpretation that anyone with a prospecting database needs to, between now and the 25th, ask all of the people in their database before they send them some sort of a newsletter if it's okay?
There is a distinction between B2C market and B2B. If people are consumer, yes, you have to ask explicit consent. But if they are not consumer, it's not necessary to ask explicit consent. So we have there is it depends. It is opt-in, opt-out. This is a rule that exists, I think, in France, and I don't know if it's in England, but it's in France. We can also keep sending some newsletters in B2B without requesting the explicit consent.
Okay, so that's a big deal, right? Because
So that
I
we
think
can prospect without getting explicit consent.
that what we just heard was for B2B business, for B2B, business to business, that we don't need that consent ahead of time. But if it is a B2C, a department store advertising to consumers, that they do need the consent. Is that where the line is?
Philippe would like to emphasize and to say that it's prospection is legitimate between two professionals in the business. So this is why in the B2B you can keep sending newsletters without asking explicit consent.
Okay, that's a huge deal. That's a big deal. Okay, we have another question, and please either Laure or Philippe or Chris, how is it going to be enforced and in the U.S. and the accountability? Is there a U.S. agent that will kind of will an email come from someone in Europe to the person in the U.S. and then when it comes time to find them, how does that work? Is that all kind of worked out, or do we know how that process works for a company that's sitting in the U.S. or outside of Europe?
Well, I don't know yet personally, but under the Privacy Shield European Union law becomes enforceable. So the authority may go through your court, maybe, or your, I don't know, to be honest, I don't know how it will be enforceable in the US. So I cannot say.
Would you imagine that maybe the first targets could be multinationals that have, like say it's a US multinational that has operations in Europe, that they would enforce it at the European location?
Yes, at the beginning, this regulation was made for the GAFA, for Google, Amazon, Facebook. It was a regulation for them, and now that we know they are compliant, or they will be compliant on the 25th, that means that there is it's an evidence that it will be enforceable in the US. But to be honest, I don't know sufficiently your legal system to say how it will be, how this regulation will be enforced in the US.
Okay.
Do you have an idea? I'm asking to Philippe, comment est-ce qu'ils vont rendre obligatoire? Okay, Philippe says. We have an information from Philippe. If you process personal data of European residents, you are forced to have a representation in Europe. And this representation will be legally forced to pay the fine if they are not compliant. But so if you process data, personal data of European resident, you have to be represented in Europe by a company or something.
Oh, okay.
But that's what I thought.
That's significant.
The chances of the likelihood of this are just
Okay. So the question is, what's the likelihood of that being enforced? I mean, that's a general question. I think you would have a sense of that. What's your sense of how quickly the enforcement's going to start here? How do you think it'll happen? Will they go after an Amazon early to make a point at someone? They're probably not going to go toward a small company, I wouldn't think. But what do you think, Laure?
For small company in the US. How can it be enforced?
Or anywhere in the world, should a smaller company, small to medium-sized company that's relatively under the radar wait for some bigger entities like Amazon to get hit first?
No. The CNIL, the French authorities, say that they won't fine at the beginning. They will give a formal notification, so they will not fine with penalty immediately. But I mean, it's not really a financial issue. It's for the clients. The European companies that will transfer your companies in the US some personal data, they will request from you the GDPR compliance. So it's not really the penalty and the sanction, but it's more for your clients in Europe. If you process data on behalf of companies in Europe, they will request from your companies to be compliant. And if you're not, they normally they may be reluctant to continue the relationship, the business relationship.
Okay.
You need to be compliant.
Okay, that sounds good. What if, and this is a question from Debbie Widener, and I'm not sure where Debbie is. What if you're in a regulated business that is required to store data for a specific period of time?
It's very difficult to give one duration for keeping the data. It's almost impossible. It depends the purpose of the processing of the data. For example, you process data of employees in a company. So the company have its employee for maybe 1 year, 2 years, 5 years, 10 years, 30 years, who knows? So it depends why the data is collected for. Does it make sense? You may, for example, the employee you quit the contract with the employee and you fired him. You need, how long do you need to keep his file and his personal data in the company? In France, it can be 5 years because we have a legal obligation to keep all this data for 5 years. But if you have a litigation with this employee, so you need to keep it longer. So you have to archive the data also. To store the data.
Archive, yep, gotcha. Very good. Another question, it looks like it might be from Japan, I can't tell. Are there details or a list of what exactly needs to be included in the consent form that we will require the employees to sign? Or, I mean, in terms of the consent form, whether it's the target or whether it's your customer or whether it's an employee, are there guidelines of what needs to be included in that and what that looks like?
It's an information notice, and it's for example, if the employees are in a company, there is some personal data that you need to have, but the legal basis is the contract, employment contract, and you don't have to request any consent to collect this kind of data. But for example, if you make some video of the employees or some other, if you video or pictures, you need to collect data for this video, and you need to collect their consent. So consent is not obliged in any cases. It depends if there is a contract as a legal basis for the collection of personal data. It's really it's really complex, but I hope I have answered the question.
I think so. Chris, do you have a form that you're using, or is it just pretty simple, pretty straightforward?
I think there's an important definition here, and it's categorization. An employee is very different to a prospect. A prospect is very different to a customer, and it's to understand the categorization of that. So, as Anwar quite rightly said, from an employee standpoint, there's certain information that you have to keep. The important point there is how you're storing that data, and is that meeting the regulatory standards that are going to be existing. And again, that's fairly standard stuff. From a prospecting standpoint, again, that's somewhat slightly different. The question effectively was, well, what consent do you need? So from a digital standpoint, there are some, I put my email address up before. If anybody's interested, we have a little checklist that we use with our clients. We've given some examples on screens that where consent is okay and where it's not okay. And it's about ensuring that those tick forms are done properly. So I can get my details. So if you want to email me, I can send a little tick sheet that would probably be helpful.
Okay, and I'll email you, and we'll include that in the blog post that we post on this event, if you don't mind.
No, not at all. This is about value to your audience. So yeah, let's get something there to help the person that asked that question.
Just to add something, with the express consent, there is a notice about that explain what data is being collected for what purpose and so on. It's there is always consent and information notice in the same at the same level.
I see. Maha Kapagaridas on her way, I think, to Greece. Thank you for your comment. And she spelled that word earlier, pseudonymization. And so that's your word of the day to look up in Wikipedia for sure. And Terry in Salt Lake City, thank you. Bonjour to you as well. You are mentioning that there is the U.S. Commercial Service, which is actually the Phoenix office is here. The Salt Lake City U.S. Commercial Service has a webinar on May 22nd, specifically about the U.S. side of things, and so we'll include that in our background. Thank you, Terry, for sharing that. And now, Donahy Montez, you're probably in California, based out of San Francisco, or you may be traveling in Latin America. Thank you for your question. It's, for some reason, very small on my screen, so I'm going to take my glasses off and see if I can enlarge it. If a customer logged into the app and gave information traveling to Europe, should we need to comply? So this is, I think, an app question, Chris.
So if they logged into the app whilst traveling to Europe, well, it's all about where that individual is based. I mean, are they based in the US? I guess for context.
Okay. So one of the first questions.
Is that part of the question?
I'm assuming that, let's say a Japanese person in someone's database travels to Europe. Does that person covered under GDPR? Probably not, I'm guessing. It doesn't cover non-European residents, or does it?
If they are not, my understanding is that it doesn't in that regard. But again, I probably want because that has been an area of concern, I know, for a lot of people. But my understanding is that if somebody doesn't reside within the European Union, they are literally travelling and passing through it. But effectively, they've got an application on their phone that they've consented to give data to an organisation. Then effectively, that's okay.
Okay, that makes sense. I'm sorry.
But what about the European who is here in the U.S. for some period of time, but is illegally a resident of Europe?
Okay, I don't know if you heard that question, but what about the European that's traveling to the U.S. or to Japan or wherever? Does it cover a resident that's traveling in other parts of the world?
As far as I'm concerned, yes, it does, because I know for the way that we protect ours, we deploy employees, although we have people in Phoenix for several months at a time. They're European residents. From an employee standpoint, we still have to protect their data in the same way. Even if they're clients of ours that operate out of the US, we are still bound by that legislation.
Yes, for example, I give an example. If I go in an hospital in the US I'm a European Union resident, and the hospital is supposed to apply GDPR regarding my personal data.
Okay, very interesting. Another question from here on the floor. Does GDPR require companies collecting data to tell the customers or individuals where and how data will be collected? For instance, across devices, applications, and websites. Is there an obligation to confirm to them how that's being stored?
Yes.
Yes, absolutely. Both. Yeah, but both. Not. It's you. If I have access, if I've been on a website and that website has collected any data from me, I have to have given consent for that data to be collected. Now, if that organization that has collected that data intends to use that data multi-channel, i.e. it's not going to just use it from a web element, it's going to move it to mobile, it's going to try to use it for an in-store experience, which is a physical experience, and it's using my data to do that, I need to have given explicit consent for that single customer view journey to take place.
So part of that question is with the third-party brokers, because you don't have a direct relationship with those, so they're like Remora, so they're basically just bombing on to the website and collecting information. How do they?
So third-party suppliers,
third-party brokers that are gathering information off the website.
Third-party brokers. We certainly need to be aware of what third-party brokers are doing with this, right? With the information.
Absolutely. So but again, the context of a third-party broker. So if you have a data collection form on your website and you are passing that data to a third party for whatever reason, whether that's for them to do specific analysis of that data, to give you information back for whatever reason, if that is on European Union residents, then they need to give express consent for you to do that, and you need to ask them and be absolutely unequivocally clear that you are intending to do that.
Okay.
What happens like
Very good.
Facebook and Google will do it across devices. So if it's on your phone, then they're collecting data from all these different places that you go, from your GPS location, so I'm just saying they have to actually tell you where they're collecting it. Is that
Okay.
what you're saying?
Did you hear that question?
Yeah, that's right. So this is very specific around mobile, because obviously cell devices collect huge amounts of data, and it depends what data it is and how much data is being collected. So a lot of consumer brands, for example, with mobile technology are able to understand what kind of routes you've been taking, where they're able to gather information, not just on yourself, but on your activities, your shopping behaviors. So a lot of, from a marketing standpoint, a lot of marketers want to understand consumer behaviors. So this is obviously something that's quite interesting and quite important. And it comes down to how much data is being collected and the accessibility that you give to the user to be able to give consent to do that. So at the moment, the vast majority of a lot of mobile applications specifically essentially just pop up a little notice periodically to say this application has been collecting data or doing something in the background, but it doesn't explicitly say what. It doesn't also advise you what information it's holding on you. So the legislation now clearly states that what has to happen is that within that application, you need to be, me as a user of that, should be able to clearly see what data you're collecting on me and give me the choice as to whether or not I want to allow you to do that. That's effectively it. So if you have applications out there that are consumer apps, those applications do need to be looked at and assessed as part of that data, as part of that review process that needs to be done to be compliant for GDPR.
Very good. We have come to the end of the hour, and we do have some more questions, and unfortunately we won't be able to get to them. As Laure, you mentioned at the beginning, this is a heavy, big topic. And so I think we've done a heck of a job, and you guys have done a heck of a job of pulling this together. So if we could get a round of applause from our audience. Thank you very much. You guys are awesome. And we'll undoubtedly, this is not the end. I mentioned about that event, and we'll kind of compile some additional GDPR information on a blog post that'll go out early next week that will actually include this as well. I also want to mention one of the things that we do is we do these events regularly, and our intent is to do this every week. And over the next month, we actually do have 4 events coming up. The next one, I believe, is about sales, basics of sales around the world. And so I'm guessing the GDPR will come up in that conversation as well, in terms of how we maintain data going forward. And it also kind of takes sales to other issues related to sales. We have an event coming up on women in global leadership. We have an event coming up on exporters, and happen to be all women. I think we have one more event that I'm missing out on, but check the Global Chamber website at globalchamber.org. Go to the event tag and you'll see all of the events. And then from your particular chapter, go to your chapter website and you'll see the things that you can get to locally. I'd like to thank Polsinelli for hosting this event. Thank you guys. As always, you're a tremendous partner. We really appreciate it. Garrett, Mike, Cindy joined us, and thank you for all your help. I believe there actually are a couple events from Polsinelli coming up. I know I got an email the other day about one here in Phoenix. There was a webinar that was coming up. So if you haven't checked out Polsinelli, go to polsinelli.com. Alan Carey, thank you. We thought we were going to need a lot of translation. We didn't need so much today. But could you just kind of introduce yourself and then?
Just want to say thank you. Merci beaucoup à tout le monde pour votre participation à cet événement.
And Alan will provide information about how to contact Alan and all of the speakers today. If you have any trouble with getting any information, whether you want to reach anybody that you've seen today, send an email to info@globalchamber.org and we'll be very happy to help. Thank you all. Thank you all around the world. Have a great day, night, or morning.